Welcome you all. Now we will discuss on compounding of offences under Companies Act 2013, specifically focusing on Section 99 and 441. We will explore the definitions, scope, eligibility, procedures, powers, impact related to compounding offences. Our aim is to provide a comprehensive understanding of how companies can rectify minor contraventions of the Act without facing a lengthy legal battle. Understanding Section 99. This is the definition and scope of offences. Section 99 talks about the punishment for default in complying with provisions of Section 96 to 98. If any default is made in holding meetings of the company in accordance with the Section 96, which talks about the annual general meeting, or Section 97, which talks about the powers of the tribunal to call AGM, or Section 98, which talks about power of tribunal to call meetings of the members, or in complying with any directions of the tribunal, the company and every officer of the company who is in default shall be punishable with a fine which may extend to 1 lakh rupee, and in the case of continuing default, with a further fine which may extend to 5,000 rupees for every day during which such default continues. This is what Section 99, punishment for default when complying with the provisions of Section 96 to 98. I will talk about Section 441. 441 of Companies Act 2013. Compounding of offences. Section 441 of Companies Act 2013 provides a mechanism for compounding certain offences, allowing companies to pay a sum of money instead of facing a prosecution. This section aims to reduce the burden on the courts and encourage companies to rectify their mistakes quickly. The compounding process involves admitting the offences, paying the penalty, and obtaining an order from the appropriate authority. So any offence punishable under Companies Act 2013 committed by a company or any officer may be compounded by either tribunal or regional director, where the maximum amount of fine imposed for such offence does not exceed 25 lakh. So if the maximum amount of fine does not exceed 25, then it comes under the purview of the regional director. Beyond that, we have to approach to the Honorable National Company Law Tribunal. Compounding is applicable to offences punishable by fine only, or by fine or imprisonment. Section 441 ensures a balance between enforcing compliance and allowing companies to correct minor transactions, minor mistakes, or minor transgressions, fostering a more cooperative regulatory environment. Eligibility criteria for compounding under the Act. So to be eligible for compounding under the Companies Act 2013, there are certain criteria. So firstly, the offence should be compoundable, meaning it is punishable by a fine or imprisonment, not and or. Secondly, the company must not have committed the same offence within the preceding 3 years. Repeated offences are generally not eligible for compounding. So the company must not have committed the same offence within the preceding 3 years. And repeated offences are generally not eligible for compounding. Additionally, the company must demonstrate a willingness to rectify the default and take corrective measures. Fraudulent or malified actions or disqualify a company from seeking compounding. So it shall be a compoundable offence. So it means fine or imprisonment or and no repeat offense, no similar offense in the last 3 years, and willingness to rectify, demonstrate corrective actions. The procedure for compounding, a step-by-step guide. First, convene meeting of the board. Determine the offense and calculate the fine to be paid by the company and our officer in default. As per the relevant section, we can calculate. Then pass the resolution. Resolution to file an application for compounding of offense. Resolution to authorize director or any officer of the company to sign and submit the application before the authority on behalf of the company, to appoint a professional to appear before the authority. Prepare the compounding application in triplicate. Application to be accompanied with an affidavit verifying the application, memorandum of appearance or power of attorney, copy of the notice from ROC if any, or other necessary documents. Then file E-form GNL1 attaching the application along with the prescribed fee. The fee is 1,000 rupees as per NCLT rules 2016. Based on the amount of fine, ROC forwards an application to NCLT or regional director with his comments. Then personal hearing before either NCLT or RD, and then payment of fee for compounding within the time period mentioned. Then compounding shall not exceed the maximum fine imposed for the offence so compounded. Intimation of order of NCLT or order or RD with ROC within 7 days of receipt of order by filing INC 28. So based on the amount of fine, ROC forwards, ROC will calculate, and again after calculation he will forward the application either to NCLT or RD with his comments. Then personal hearing will be there either before NCLT or RD. Then after that, the payment of fee for compounding within the time period mentioned has to be paid. And then the order has to be intimated to ROC within 7 days of receipt of the order through INC 28. Then the impact of compounding, the benefits and limitations. It provides a quicker and most cost-effective resolution compared to a traditional litigation which takes time. So it also allows companies to rectify errors without the stigma of criminal conviction. And what are the non-compoundable offences? The offences punishable with only imprisonment, non-compoundable. Offences punishable with imprisonment and fine, not compoundable. Offences cannot be compounded in case of a similar offence committed has been compounded and the period of 3 years has not expired. Section 441 subsection 2. Offence cannot be compounded in case either the investigation has been initiated or pending. This is under section 441 subsection 1. So any subsequent offence committed after the expiry of 3 years from the date of compounding shall be deemed to be a first offence. So non-compoundable offences, offences punishable with imprisonment only are non-compoundable, or offence punishable with imprisonment and fine are non-compoundable, and in case similar offence committed has been the compounded and the period of 3 years has not expired, also again not compoundable. And offence cannot be compounded in case either the investigation has been initiated or pending, not compounded. Hope you are clear. Thank you. This is what compounding of offences under Companies Act 2013, specifically focusing on Section 99 and 441. Thank you.